Badara Consult educational videos. We produce videos for students of Chartered Insurance Institute of Nigeria, Chartered Institute of Personnel Management of Nigeria, Prince 2 Project Management. However, it's a growing list. For now, we are limited to these areas of interest. Please do well to like our videos on YouTube and subscribe to our YouTube channels to enable you to see more of our videos, those that we have produced before now and those that are to come. Thank you. Sources of English law. We have two principal sources. We have the legislative or legislation, and we have judicial precedents. These are the major sources. These two are classified as the major sources, while the minor sources are local custom. We have legal books, and treaties. Treaties, it's agreement signed by two or more countries on specific area of concern. Talking about legislation, we talk about law which has been created in a formal way. The legislature law created in a formal way, as set down in writing, set down in writing. The principal form, which is parliamentary legislative, takes is Act of Parliament or statutes. Act of Parliament. It comes into force by Acts of Parliament or statutes. For this region, legislation is sometimes called statute law. Statute law. This could pass as an objective question. Statute law. Statute law. The legislative process is well documented. That is, before a law can be made, a formal process must be followed and approval of both houses, because is legislation. Concern, that is, it must be approved by the houses of assembly. In Nigeria, we talk about before a law it can be made or is made in Nigeria. For example, new law. Talking about new law. It must be introduced either by the government through the legislative arm. The government often consults interested parties and the general public on those proposed laws. A new law will be drawn up in the form of a bill. A bill may be either be public or private. If the public bill, public or private bill, if they pass through the legislative process and becomes law, they are then known as public or private acts, respectively. There are procedures for enacting of public bills. Now we want to limit the scope to public bills. One, the procedure for enacting of public bills. Generally, in presidential system of government, the processes a bill goes through before becoming a law is essentially the same. Countries, however, have minor differences. The processes of lawmaking generally requires a long period of deliberation and consideration of many interests and implications of the bill. A summary of the process and the tasks involved are discussed below. We have the first stage. The first stage is the identification of the bill for the need for a bill. This bill can be a new one, introducing a new idea not yet covered by existing law. It can also be an amendment of an existing law which is thought to be inadequate, either because of some changes in the policies of the government or change in society. A bill can be initiated by anybody, but only a member of the House or a senator can introduce it on the floor of the House or the Senate. Stage 2. This is the first reading after it is introduced by a member of the House or Senate. The clerk of the House or Senate usually does the reading of the bill scheduled on the House or Senate calendar. A schedule indicating the day and time bill will be receiving reading. He or she reads the short title of the bill for the first reading and then proceeds to table it. The word table is used to mean the action by which the clerk places the bill on the table before the Speaker of the Senate President. Second reading. This period is when debate occurs on the bill. Usually speakers on a bill are allocated time of about 5 minutes, 5 to 7 minutes to speak. Debate commences with a motion by the Senate or House leader that the bill be read the second time. If it is an executive bill, the motion must be seconded, supported by any of the other party's leaders. When it is not seconded, the bill cannot be debated. But in most cases, executive bills are allowed as a matter of courtesy to proceed to a second reading. Then we move to the committee stage. This is the period when the committee signed to deliberate on a bill, examines it more critically. The House and the Senate have two types of committees. The first one is committee of the whole House, and the second one is the standing committees. This House and Senate have many standing committees. If the committees of the whole House is to discuss a bill, the Deputy Speaker of the House acts as the chairperson. The Speaker would leave his seat and sit at the clerk's seat. Then the third reading, after the report of the committee and the deliberation of the committee of the whole House, a motion may be moved by the bill that the bill be read the third time, either immediately or at a later date, and passed after each chamber has certified the contents of the clean copy to be accurate. Then the clerk and the clean copy of the bill. When a bill has been read, this is the third time and passed, a clean printed copy of it, incorporating all amendments. Remember, it has gone through the committee stage also, will be produced. So during the committee stage, amendments could be made. So the amendment will be incorporated and the report will be reprinted to accommodate the adjustments made and signed by the clerk and endorsed by the Speaker or the Senate President. The copy will then be forwarded to the clerk of the House or Senate, as the case may be. The copy will be accompanied with a message requiring the concurrence, passage or of the bill or agreement of the receiving chamber, either House or Senate. In this case, in the case of the executive bill, both chambers would just exchange copies of the bill, since they both received copies and discussed the bill almost the same time. When the bill is sent to either of the chamber for concurrence, three things may happen. This is very vital. You need to take note of this. The receiving chamber may agree with the provisions of the bill and hence pass it. They may agree with the provisions therein. 2. The chamber may not agree to some part of the bill, hence make amendments. 3. The chamber may not agree with the bill at all and therefore reject it in its entirety. This situation is however rare and has never been witnessed in Nigeria. Generally, no amendment can be entertained after the third reading stage. However, if a member wishes to amend or delete a provision contained in the bill or to introduce a new provision, he or she must give notice of his or her intention. Stage 4. Another way in which the president is involved in the art of lawmaking is by signing bills into law. A bill does not become law until the president signs it. the clerk of the National Assembly will enroll the bill for the president's signature. Enrollment is the production of a clean copy for the assent of the president. The clerk of the National Assembly produces the clean bill, certifies it, and forwards it to the president. The president, however, has 30 days to sign the bill sent to him. 30 days. This is important. By the National Assembly. If he or she disagrees with the provision of the bill or some aspect of it, he or she can veto by withholding his assent or signature. We have seen this even under the Muhammadu Buhari's administration. Within the 30 days, the president must communicate to the National Assembly his or her feelings and comment about the bill. The president must state the areas he or she wants amended before he or she signs the bill. Before the last general elections, the electoral bill was amended by the National Assembly and sent to the president for assent. The president, in his wisdom, withheld his assents, citing areas of divergence, and the bill was sent back, transmitted back to the National Assembly for necessary amendments. The amendments, however, were made, and the bills forwarded again to the president, but the bill eventually was not signed. So it was not put to use for the 2019 general elections because it was not an act, as it were. However, if the National Assembly agrees with the president that the bill be withdrawn for deliberation on the amendments suggested in this regard, it was done by Bukola Saraki, Senate presidency. During Bukola Saraki's Senate tenure as the Senate president, it was sent back by the Muhammadu Buhari government and amendments made. However, the National Assembly is empowered by the Constitution to overrule the veto if the president fails to sign. After 30 days, the president refuses to sign the bill and the National Assembly is not in support of the president's amendment. So the two chambers can recall the bill and repass it. If the bill is passed in the form it was sent to the president by 2/3 majority votes in both chambers, the bill automatically becomes a law, even without the signature of the president. This happened in the case of Niger Delta Development Commission bill. The two chambers passed the bill into law after the president failed to sign it within the time that is prescribed by the Constitution for him to do so. The sources of the legislature, judicial precedents, the minor ones we talked about, location, legal books and treaties, local custom. When we talk about local custom, is similar. This is local custom, please. Local custom. Similar to common law. Decisions made by preceding, earliest judges that becomes binding precedent, a point of reference to other judges when similar cases in future come up. Then we have legal books, relevant legal materials. We have treaties. These are binding legal documents. They are sources of English law. And Nigerian law or Nigerian legal system is fashioned in line with that of the United Kingdom, England.